before. Oh, okay, looks like I got it. So thank you for joining us today. Our talk is entitled Patients, Providers, and Police, Clinical and Ethical Ambiguities Related to Law Enforcement Presence. My name is Utsa Khatri, and I'm an assistant professor at the Icahn School of Medicine at Mount Sinai, and I'm joined here by...
Hi, I'm Will Weber. I'm an emergency physician at Beth Israel Deaconess Medical Center, and I help lead the Medical Justice Alliance.
So before we get started, neither of us have any financial interests or conflicts of interest to disclose. This is just an outline to get everyone oriented to the presentation today. So we'll first start by starting to just contextualize law enforcement officer presence in the emergency department. We'll then move on to a clinical case and then discuss some clinical and ethical best practices. We'll go over a couple of relevant publications on the topic. And then the last few slides are kind of just some rapid fire resources, because there's no way we're going to be able to cover everything related to this topic in the hour that we have with you today. So we actually wanted to start with sharing some quotes from this qualitative study that was published in the Annals of Emergency Medicine. I believe it was now 2 years ago. And it was a qualitative study where the team interviewed clinicians in an emergency department in California. And they analyzed the qualitative data on themes that were prevalent from the conversations. And the take-home message really was that these participants, again, these are clinicians, mostly residents and attendings, I believe, described that their experience with law enforcement and the emergency department was mixed or variable. And these are two quotes that illustrate kind of both sides of the coin, as was presented by the study. So one person said, "We do have many patients that come in that are large or verbally or physically abusive. I feel a lot more comfortable knowing that there's people there that could get involved if needed." And then on the other hand, someone else said, "I've seen nurses divulge test results, physicians too, test results, scan results, patient treatment, where they're going, other sorts of things which are protected health information." And so what you can see here is this tension. These are two different people's perspectives, but collectively there's this tension between, feeling some sort of dependency on the police officers in the emergency department, and then having this recognition that things are happening that shouldn't be. And so, when we talk about police in the hospitals, but particularly police in emergency department, we can't, talk about this without recognizing that the emergency department is the social and safety net of our society. That's actually why a lot of us, if not all of us, chose the field that we chose. We take care of anyone at any time, and we're the only space within the healthcare system that has this mission really that's legally mandated to us. But we also know that because of inequities in both the institution of healthcare and just society at large, due to many forces, namely structural racism, but also economic marginalization, stigma of poverty, of homelessness, of substance use disorder, we know that emergencies don't affect all people equally. And we know that the same people who are more likely to need the emergency department, the more likely to use the emergency department as their primary access to healthcare, are also the same communities that are more likely to be over-policed and face interactions with law enforcement. So why are police in the emergency department in the first place? I'm sure there are reasons that you've observed, especially because this is a national audience. There might be, reasons that you've observed that I haven't in the places that I've worked, which are mostly, which are all in the East Coast. But these are some of the reasons. So first, they provide security and deterrence. Different health systems may have either police officers or security guards stationed in emergency departments to provide security to staff and other patients. And we know, and it was illustrated in that initial quote, we know that people who work in the emergency department are at high risk compared to other places in the hospital for being victims of both verbal and physical assault. However, there's nothing really that suggests that the presence of police in emergency departments prevents these assaults, but nonetheless, many hospitals, especially public hospitals, are likely to have police officers there every day. Providing security. We also know that police officers may bring patients or themselves or their colleagues into the emergency department to seek care. Whether that's someone who was injured or had a medical complaint while they were being arrested or booked. There are multiple conditions, either injury or otherwise, that may result in a trip to the ED for medical treatment and screening. Police officers might also come to the emergency department to investigate crimes, whether those are violent assaults, concerns for driving under the influence of alcohol, sexual assaults. There are different reasons that the police might be there to gather evidence and collect information. And then there's a mix of other reasons that they may be there. They might be there to take reports as requested by patients. In some places like Philadelphia, where I worked before, they're there actually transporting patients who are victims of gun violence. And there are other reasons, I'm sure. So when we think about this intersection of emergency care and law enforcement activity, it's important to keep in mind some medical ethics. These are ethics that we all learned in medical school. They are the pillars of our practice of medicine. And it's important to think about them when we're talking about this particular intersection. But I wanted to give you guys a bigger framework to think about these ethics and how they might conflict with the activities of law enforcement officers. And that framework is that of dual loyalty. And dual loyalty is really, just as the name implies, conditions or dilemmas that arise for physicians when their role as a healer conflicts with their obligations to or the demands of a third party. Now, in this case, we're talking about the third party being the state represented by law enforcement officers. But it's important to remember that that's not the only third party that we interact with when we're taking care of patients. Sometimes an insurance company can be a third party. Sometimes our own healthcare institutions can seem like a third party. But the point is that not everyone has interests that completely overlap and align. And so we're kind of stuck in the middle between our patients and said third party. And so why is this problematic? Well, first of all, it can compromise our medical judgment, if we're practicing in a way that's different because we have to consider, someone else or something else's interest that we don't normally. We may practice clinically differently. Sometimes we're imposed to do things, medical procedures that we wouldn't do otherwise in, the medical care of the patient. We are likely to provide a lower quality of care. And the last one is really important because of who the third party is in this case, law enforcement officers and the authority that we all defer to them in society. often it can encourage us to remain silent when we wouldn't otherwise. And an unfortunate and recent and very tragic example of this was with the murder of Ivo Ateneo in Virginia that happened just a couple of weeks ago, where he was taken to a psychiatric hospital, eventually was asphyxiated when several police officers put their body weight on him in an attempt to restrain him. But the video that exists is really striking in that there are clinicians in the room who don't intervene for minutes as this is happening. And so the dual loyalty can create some really problematic and harmful conflicts. And so there is an international working group on dual loyalty. There's a chapter that they've written in this book, Physicians at War. And ultimately what they recommend is that we as health professionals must be able to identify when these conflicts are happening in our care. And whenever possible, it's our duty to protect the patient. So I want to really quickly talk to you about a clinical case that I had during residency that really got me thinking about this problem and intersection. And then I'm going to pass it on to Will. So this was a case of a 17-year-old boy. I was in West Philadelphia at a trauma center. I mentioned that in Philadelphia, police officers have the authority to transport victims of gunshot wounds to the hospital. And so this young man had been brought to our trauma center in the back of a police car. He was 17. I mentioned that he was really scared that he was going to lose his hand. And, you know, as we were doing the secondary survey, I noticed the police officer who brought him was starting to ask him questions. And the questions, you know, first started off, what happened, whose gun was it? And then it started becoming a little bit more uncomfortable and what I felt was inappropriate. Do you have a gun? Who were you with? Things of that nature. And I felt incredibly uncomfortable. I knew this wasn't right. No one had ever prepared me in my clinical training up to this point for this situation. And so I went to my attending and I said, this is a minor. He's, being questioned. We're not even done with his clinical survey. We have to do something. Can we ask the police officer to leave? And in this situation, my attending said, the police officer is just doing their job. We work together often in these situations. And so this didn't sit well with me, and it led to multiple other efforts that I won't talk about today, but I'm sure all of you have been in some sort of situation where the voice in your head or your gut or your heart just tells you that this isn't right, but you can't rely on a policy or a rule or even a teaching to help you kind of manage the situation. So I'll pass it on to Will.
Thank you all so much. And I appreciate the introduction to all the legal framework from Ucha. So I wanted to transition now, since we've talked a little bit about the legal framework. We've talked about cases we have encountered on our own in the ED. And just talk a little bit more about how do we approach these issues when there are these fraught ethical situations where we are trying to maintain the rights of the patient, but also maintain public safety. We can go to the next slide. And when law enforcement officers typically will come into the ED, they're usually going to try to want to access kind of three types of information within the ER. And so first we'll be talking about privacy and how do you support patient privacy with that. So I think the overarching theme that I would want everyone to understand is that in general, patients retain the same rights they would have out on the street when they're in the ER. So first off, we'll talk a little bit about information. So Jeff in the chat had mentioned about HIPAA. And so we all know how to protect patient information. We're not sharing on the street, we're not sharing with others, we're not posting things online. The same things would apply with police, as they are just another person on the street and they're not privy to protected health information in general. Now, officers will ask for information about patients, and this is generally when it's surrounding a crime that was committed. So they're trying to get more information about either the perpetrator of whatever happened or just this situation. So there are state-specific guidelines in terms of what is mandated reporting. Probably all of you who are practicing physicians would kind of have an understanding of, firearms in my state or animal bites in my state are reportable. And in those cases, you are allowed, and you many times are required to at least give some basic information. Now, that being said, in terms of HIPAA, so that falls outside of HIPAA, and there are like other laws dealing with that, but it doesn't mean that you need to give all the patient information. So in general, what officers need to know is just a limited information. So they can be given the name of the patient, the address of the patient, their date of birth, and then the type of injury, and usually like a status, whether it's critical illness, whether they're stable, things like that. They don't need to know the patient's medical history. They don't need to know if they are intoxicated. They don't need to know these other things. So outside of a specific reportable crime, in general, protected information should remain protected. So if there's not a specific reportable crime, like a gunshot wound, if ICE were in your ER and they were asking about a patient's whereabouts or asking for documentation information, things like that, that would not be something you would be allowed to share. So again, for information, generally for reportable crimes, you can provide a limited amount of patient information. So the second area that officers will often want to gain more information is from the patient themselves. And this is oftentimes to collect evidence to get their take on what happened in the situation. So I kind of break this down into three circumstances that will generally allow this. So first, we'll talk about consent. So this is if the patient consents to speaking with the officer. Usually I try to have the officer out of the room when you're actually asking the patient consent, because if you have multiple law enforcement, it can feel a lot more coercive if they're in the room and you're asking the patient, hey, can this officer speak with you? And so usually I'll just politely tell the officer, let me go ask the patient if they are open to speaking with you about this. So if the patient gives consent, then the law enforcement officers can speak to them after you've kind of stabilized them from a medical situation. Now, this can also be if they do no longer want to speak to the officers, if it goes in a weird direction, they can still withdraw that consent. And as long as they're not under arrest or something like that, then the officer should not be speaking with them further. The second kind of the large category would be if there's a court warrant for the patient, either that there's a warrant for their arrest or detainment, and that's documented for a specific patient, a specific reason, or if there's a law, an existing law that requires reporting, such as a shooting. So that's kind of a court mandated report. And then finally, if patients are already in custody, so if they're coming in either from a jail or another correctional facility, and law enforcement are with them already, they are allowed to remain with them. Now, this also brings up an issue where many times we still want to protect patient privacy. Going back to privacy and HIPAA, these law enforcement officers, if they're correctional officers at a facility, they do not need to be privy to all this patient's information. And many times the patient might not want to divulge information that could potentially get them in trouble later. For instance, if a patient were using substances in the prison, and that could be contributing to their chief complaint, if they're sharing with you as a physician and it's overheard by the officers, that could potentially be incriminating. So in general, we always try to have officers step out for interviews. In general, this is okay as long as officers keep a line of sight. So usually I'll just ask them, for patient privacy, I'm going to ask you to step out of the room. And usually as long as the patient's restrained, then you can get them out of earshot so you can have a conversation with them. In general, with all these, if officers are going to be talking with the patient, this should be after they are medically stabilized. So like the situation with Joe, she was mentioning, this should not be during the primary or secondary survey. This should be later once you are finished up, and it shouldn't be interfering with the medical side of things. And then finally, I wanted to talk a little bit about property. So this is the other place where sometimes officers want to get access to patient property, whether they're concerned there might be contraband or drugs, things like this. Again, this falls under the same jurisdiction as everything else. If they have a court order for specific property, then they could be granted access to that. But in general, it's a patient's property. They're not allowed to have improper search and seizure without a warrant. The one example that might come up is if the property is what appears to be contraband in plain view. So if an average person walking by the room could see something that looks like contraband, looks illegal, then the officers are allowed to investigate that. So if there's a big bottle of pills or what looks like a dime bag of heroin or something like that, then that's allowable. So that's kind of wrapping up all of privacy. Now, ASAP also has a policy statement that really reflects all of these different things. So usually consent, if there are laws or regulations, or court order for these. And you can always defer to that in your clinical practice, or if there are issues with your hospital policies. Now, in terms of the academic literature, this also supports kind of what we've been saying. There are similar patient rights, and also we've seen is a very strong emphasis on physicians protecting the rights of patients. It's a moral obligation for us to safeguard protected information of patients. As Usha was mentioning, many patients are undocumented. Many patients might have things that could be incriminating, and yet they turn to the ER for care. And many times they don't have access to all the typical venues to get care, and the ER is the place they can turn. So we want this to be a safe place where people can get the care they need. And by safeguarding their protected health information, by safeguarding their persons, we can help ensure that that happens. Now, the one other thing this study highlights is in terms of state laws. So this is a big caveat for all of you practicing in each of your own practice environments. There's considerable variation between what states mandate is reportable. So you can see child abuse just generally across the board, everyone mandates reporting, but many times different injuries might not be reportable in one state, but might be in another. So it's a good thing to know your state guidelines. Most people already do because you bump into this frequently, but it's just something to be aware of. So next we'll turn to the issue of consent. Just as with consenting with speaking with officers, patients generally retain the right to consent for all testing and treatment, just as any other person would. So for instance, this comes up oftentimes with people who are where officers are concerned whether they might have intoxicating substances on board, whether they might be under the influence of alcohol, things like that. And this can be tricky for emergency physicians, especially because you'll have a patient who does not want their blood drawn. You have an officer who says, well, we have an implied consent law, and so they consent to treatment or testing. So it is tricky. Again, it is many times state specific, but what I will say is most states, even when there's implied consent law for drivers on the road, that would mean if you are driving, if you're behind the wheel of a vehicle, it implies that you're consenting to treat for testing for alcohol levels. With that, most states, even though it's implied consent, it does not mean that you can take their blood or other samples non-consensually. It just means that if they rescind that consent, then they automatically forfeit their license for at least a year or something like that. So if with most of these situations, in general, you do not draw lab or other testing on patients, you do not perform body cavity searches, other things without their permission. And usually if there's pushback from law officers, in general, what is safe to do is just defer to staff safety and say, we are not prepared for this. This could be dangerous to ER staff to try to restrain someone who might act violently, things like that. And so we can't do that here, but you can, if you are going to do it, you need to coordinate on your own. So that's kind of the first one. Going back to that, continuing with consent. So other there are some limited exceptions. So some states will say if there's exigent circumstances, mean it's very time limited circumstances or emergencies where something could change very quickly, such as an unconscious DUI or patient who's concerned for DUI who's unconscious. They could draw lab testing. Or for other like public health risks, such as tuberculosis, if there's concern for a patient who's incarcerated who might have tuberculosis, they could force testing, things like that. Court orders, again, are a very gray area and should be usually just escalated to any like med legal or risk management department. In general, yeah, this is pretty much the rule of thumb is do only what's medically necessary. If a patient does not want to do it, do not do it. Or if there's a concern and you're considering doing something non-consensually on a patient, escalate it to risk management. Don't make that decision yourself. So, another topic we will bump into many times is restraint. As we saw with the initial image that we did this talk on before, restraints can conjure up different emotions for people. Some people feel more security. Some people feel kind of this aghast that patients are chained in the ER. Now, I want to just acknowledge that unfortunately the ER is a place where workplace violence is endemic, and many people even here probably have been injured by patients, whether in custody or not. So we recognize that the goal of restraints is for safety for the staff and for the community at large. But we also recognize that many times restraints are used indiscriminately and many times can cause harm to patients without increasing safety. So I think some broad considerations with restraints. So I think the first point I would bring up is the difference between medical versus administrative restraints. So we have like very, very strict guidelines in terms of medical restraints where we need to be performing routine documentation. We need to show why the restraints are medically necessary and things like that for medical restraints. Now, for shackles, handcuffs, things like that, those are classified very separately and those are labeled administrative restraints. They're not for a medical purpose, they're for a safety purpose. So you don't have to have the same documentation for those. Now, that being said, restraints should not be interfering with your medical exam. So our goal is to have the least restrictive restraints possible that would still allow safety. So we've had many issues where, women who are pregnant would be restrained even during childbirth or delivery, even though there's never been a case of someone injuring a healthcare person who's pregnant, delivering, or trying to escape. And so there are many circumstances where they might not need 4-point restraints, they might not need 2-point restraints. And so if you can advocate for your patients and say, what is the concern here? If this is an 80-year-old patient who has dementia, what is the concern here? And can we do something less restrictive? It also should not hamper your exam. So if you're trying to get a good shoulder exam and they can't range it because of the restraints or shackles, you should be asking the officer to either remove it temporarily or move it to a different extremity. And then finally, discharge planning and follow-up is something that can be different for patients who are either involved with law enforcement or in custody. So first, for discharge, you want to figure out where is this patient going after the ER, because many times that can change things up. So if you're sending a patient home and they can pick up their prescription for the anti-epileptic medications or antibiotics on the way home, that's very different from if they're going to a prison where they might not be able to see anyone medical until the morning. So considering, will they have access to the medical needs they have over the next 24 hours? The other thing is for patients who are in custody, any written paperwork, any other things like that is considered contraband in legal facilities, in these carceral facilities. And so they will not be able to have their discharge instructions with them printed out. So that's very, very important, why you should both explain it very well to them and then explain what they need to do over the next 24 hours so that at least they get some verbal discharge instructions. Now, for follow-up, and this is specifically for people who are going to a carceral facility, it's really, really important to have clear details because this is going to be your handoff to the medical staff at the carceral facility. So providing specific details of follow-up, they need to follow up with ortho within 2 weeks or things like that, can go a long way to actually getting them the care they need. And then many times patients they won't be able to pick up Tylenol, they won't be able to pick up Benadryl or over-the-counter medications unless they go sometimes the commissary, or there's like a small store in the facilities. Sometimes they will have it. So it's really important, even for over-the-counter medications like Tylenol, ibuprofen, prescribe it to them so that the medical staff of the facility can make sure they get that.
Great, thank you so much. So I'm just going to show you a couple of publications that I think are worth noting. If there is one that you read, I'm going to suggest that you read this article in the Harvard Law Review from 2021. It's published by a lawyer and a legal scholar named Ji-Sun Song. She, in my opinion, is really the legal and ethical thought leader on this topic. And I've heard her speak a few times before, and she talks about how her interest in this space really came from all of our interests in this space, which is just seeing something in the emergency department that didn't sit right. She was a public defender. She was at the hospital with one of her clients who was injured actually by the police officers, and what she witnessed between the clinical care team and the law enforcement officers really inspired her to kind of look further into this topic. And so this law review article is the only law review article I've ever read to its entirety, but it is so relevant to this topic and what we do. There are 2 constitutional amendments that are described and really relevant to this topic, and they are the 4th and the 5th. So the 4th Amendment prohibits unreasonable searches and seizures, similar to what Will described earlier, kind of that in plain view, plain sight doctrine. And then the 5th Amendment is a right that we all have against forced self-incrimination, which kind of came up in that case that I presented initially. And again, this is a very thoughtful, thorough, and well-written but long law review article, so I'm not going to be able to do it justice in summarizing it. But there are 3 sections. I just want to give you a little preview, and I really encourage everyone to read it. The first section is really a lot of what we already know, how the emergency department is the safety net of the safety net, how other parts of the hospital or healthcare system, hospital closures, and medical and social vulnerabilities of the patients that we serve make this space particularly fraught for marginalization, and why she talks a little bit about why police are in the ER in the first place. The second section is really like the meat of the legal considerations, and what she describes is that the few times that this has been decided in court, the courts really have treated the emergency department as an extension of the public street. They don't consider the medical vulnerabilities of patients in the emergency department. So they don't consider that, a patient who might have gotten pain medication or sedation for a reduction, or even just someone who's injured, in pain, scared because of whatever is going on medically, have vulnerabilities that are different from people who are just walking on the street that may encounter a law enforcement officer. She also describes how the context of this has really enabled police to exploit the assistance of medical professionals. So going back to the example of search and seizure and of things, possessions of the patient that may be in plain sight, she describes examples of situations where the medical personnel, whether the nurse or the physician or someone else on the team, has searched the patient per hospital protocol, discovered something and then handed it over to the police. And in that action has really made it be in plain sight when maybe it wouldn't have been initially. And then, of course, she describes how this creates a potential for race-based policing for the same reasons that we talked about, who's more likely to seek care in the emergency department and who's more likely to face law enforcement questioning or activity in the emergency department. And then the final section, she talks about how we might envision the emergency department as a sanctuary. She recognizes that there are public safety concerns that will continue to require, to an extent, that police are present in the emergency department. But she argues, and I think we can all agree, that we can all do a much better job within our respective institutions to better balance patient privacy, patient rights, patient dignity. A couple other studies I'm going to kind of zip through. This was a study that we worked on at Penn. It was a social observational study. Dr. Eleanor Kaufman is a trauma surgeon who I've worked with before. And what we did was just, it felt like police were there all the time. But we wanted to know, exactly measure how often they were there, where they were when they were there, and what kinds of patients they were interacting with. So we had the lead author, Rucha, was stationed in the emergency department both during day and night shifts for all 7 days for a period of time. And what she observed was that for 31% of the hours that she was observing using a instrument, an observation instrument, police were there 31% of the time. And when they were there, there was, this table 2 in the corner that's probably too small, but they were kind of in different places, sometimes in the hallway, sometimes at the nursing station, frequently in the trauma bay. This was a trauma hospital that we did the study in. There was a mix of patients who were, under arrest or under investigation, but also people who were not, who were just survivors or witnesses. The vast majority were either victims of gunshot wounds or motor vehicle accidents, although there were a few other conditions that brought them into the department. And then we also commented on how long these interactions were happening between both the patients and the clinicians. This is another study that we worked on. This was a survey study. Survey studies are, inherently have their limitations, but I was curious in, the observations and attitudes of my colleagues on this space. I felt like people had differing opinions, and I was kind of wanting to know nationally what the sense was. And so in the survey, over a third of respondents reported that they observed daily law enforcement officer presence in their emergency departments. 62% perceived that the presence of law enforcement officers was helpful for clinicians or for the clinical workup and practice. When we asked providers what they felt was highly important when they considered whether or not they gave law enforcement officers access to the patients, only 12% considered patient consent or preference as highly important. And then we asked if they were aware of any policies that were developed by their institutions to help them guide these decisions so that an individual emergency medicine doctor is not making this decision on an ad hoc basis, but only 13% were aware of any policies to guide these interactions. We also had some qualitative data that we analyzed for content analysis, and the summary of this table is that when we asked people, if a policy were to be developed at your institution, do you foresee any barriers to adherence? The answer was yes, overwhelmingly yes. And these are some of the concerns that people had. A couple of quotes I just want to call out. There was a concern about enforcement. That was a theme that came up. Who would enforce the policy, whether the law enforcement officers respect the policy. Someone said police often are quite intimidating and cite the reasons they need to access patients and why rules do not apply to them. Standing up to police often results in lots of headache. And then there was also this recognition that we needed buy-in, not just from the leadership of our departments, but also the leadership of the law enforcement agencies. So we're wrapping up here, and at the last couple minutes, I just want to go rapid fire through some resources. This was a symposium that we put on a couple years ago. This QR code will take you to the videos of all of the recordings. And this graphic, I just wanted to give a shout out to the artist, Toya Beecham, who listened to like the 4+ hours of videos and made this beautiful graphical description of what she heard us talking about that day. We're going to go through a couple more.
Yeah, so this is another one. If you guys don't want to read the full Harvard Law Review article, even though it's great, Jisong pulled together a more useful toolkit that is very readable and has some good examples for physicians who are in the ER, how to approach these difficult conversations. There are QR codes for all of these. Another one is, this is an organization called Interrupt Criminalization, and they developed a discussion guide that really challenges physicians to think differently about a variety of topics, including whether law enforcement should even be in the ER, or topics such as whether mandated reporting really serves the purposes they aim for. This is definitely more on the abolitionist side, but they're very intriguing topics to discuss, and so that can be another resource. And then finally, if you're interested in a very tangible way to help patients who are currently in law enforcement custody, who are incarcerated, I help lead the Medical Justice Alliance, which is it's a network of volunteers across the US. And what we do is review the care that is given to patients who are incarcerated in carceral facilities, detention facilities, to make sure that it is appropriate. And so what we'll do is help lawyers, judges, understand whether they are getting appropriate care and what care they should be getting. And then we also will help advocate for patients who would qualify for compassionate release. So patients who are near the end of their life, either due to terminal illnesses or dementia, who would qualify under laws, but are not getting released just because the judges or parole boards don't understand. So if you're interested in volunteering, there's a QR code to see our website. It's usually a pretty low time commitment, and it's at your leisure. We always provide mentorship and support. So I just want to thank you all so much for taking your time this evening with us. We'll open it up for questions, but please, hopefully this will be useful for you as you're going through your clinical practice. And please reach out to either of us if you have any questions. We can open it up for questions.